SwayamPrabha. Digital India. Educated India.
Dear students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. So, this is my 7th lecture, and today I am going to discuss custodial violence and human rights issues. So, in this lecture I would like to highlight those areas where custodial violence happens, where custodial violence takes place, and I would like to discuss role of Supreme Court in prevention of custodial violence. I would like to highlight statutory provisions so that students may have complete understanding about custodial violence. What are those statutes which have been enacted by Parliament or state legislature to prevent police atrocity, custodial violence, or what are constitutional safeguards, constitutional provisions where custodial violence can be prevented by using that method. So, statutory provisions as well as constitutional provisions, and I would like to highlight few important judicial pronouncements through which we will try to understand how custodial violence takes place and what are the procedures which have been incorporated in the statute, and person who is in better position, you might have seen that they many times they commit violence either to impose their wishes, or they commit violence due to teach lesson to someone. So, whenever this violence word is custodial violence comes into picture, we frequently consider that custodial violence is committed by police or by prison authorities. Though the number of cases regarding custodial violence are so high, custodial violence is frequently committed by police or prison authorities, but in spite of these two authorities, you might have seen that school principal may or school teacher is also many times as per media reports or as per reports reveal that school teacher or school principal, they also sometimes they also involved in such kind of activities. They commit violence against children in their schools. What is the statute? What is law in order to prevent such kind of custodial violence, and what is the role of Supreme Court, to what extent Supreme Court has taken initiative against such kind of malpractices. So, I would like to discuss all these things in this lecture. First of all, I would like to discuss violence in custody, either by prison. You just look at your screen. Violence in custody refers to violence by police, custodial violence, custodial death, torture, use of third degree method. So, or this kind of violence may also be committed by prison authorities. And Police Act 1861, that is a statute through which police officers and entire police system is being regulated in this country. Police Act 1862, 1861, torture by police in custody. You might have seen this kind of thing in your day to day life. Prison Act 1894, violence against prisoner in prison. Reports reveal that school teacher or school principal, they also sometimes they also involved in such kind of activities. They commit violence against children in their schools. So, with the help of these two important statutes, Prison Act 1894 and Police Act 1861, we will try to understand that what are the functions of police officers in this Police Act 1861, and what are the powers and duties of prison authorities, jail authorities provided in Prison Act 1894. If police officers they deviate from their desired behavior, if they deviate from their statutory behavior required by this Police Act 1861, so they might be prosecuted and convicted by the court, as well as departmental inquiry or disciplinary action can be taken against them by their superior authority. Similarly, where prison authorities or prison employees who are working in jail, if they deviate from their statutory behavior, if they deviate from the behavior required by the Prison Act 1894, prison authorities, the employees who are working in prison jail, they may also be prosecuted for committing violence in prison, as well as departmental inquiry may also be initiated against them. Though we have adopted these two important legislation to regulate internal affairs of prison jail authorities, as well as external affairs of law and order, which police authorities, police officers are supposed to maintain. So, though you all might be aware about Police Act, because this Act regulates that how arrests shall be made, in what manner police is obliged to arrest the person. All these things are stated in this Act statute. In spite of that, many times you must have seen that police atrocities, custodial violence, custodial death, these matters are reported by media. Second important thing is that you might be aware about the incident which happens even in prison. Indian prison system, if we talk about Indian prisons, even prisons are not safe. So, many times you might have seen that offenders are killed in prison also. So, it is only because of failure of prison system, it is only because of negligence of jail authorities. So, if such kind of incident happens in jail, in prison, or where violence is committed by police, then how judiciary will take action against them, what is the statutory provision, I will try to explain one by one. So, now come to firstly, you all need to understand that what are the rights, what are those human rights which can be claimed by a common man, which can be claimed by a human being. So, you all might be aware about UDHR, Universal Declaration of Human Rights. So, that declaration was duly resolved by United Nations General Assembly in 1948. So, I would like to quote some important human rights. Right to life, just you look at your screen. Right to life, Article 3, that is very important, because this is very precious right, right to life. It is a human right provided in this UDHR. Right against torture, this human right is provided under Article 5 of this UDHR. Right against unwanted arrest, Article 9. No one can be arrested in arbitrary manner. Unlawful arrest is prohibited. Where a person is arrested unlawfully against the law, he can challenge the legality of his detention. Another important human right is right against inhuman treatment. So, these are, you see, these are few important human rights which you need to understand. These human rights are closely connected with criminal justice system. If anyone who is deprived from his life by police or by prison authorities, then it would be violation of human right, and that victim has right to come before the court. He can challenge the legality of that detention, he can challenge his confinement before Supreme Court or High Court, without knocking the door of subordinate court or without knocking the door of district court. If this kind of protection are already provided in international instrument, all these rights, we have also adopted all these rights in our legal system. Constitution of India, supreme law of the land, has also guaranteed these rights in Part 3rd of the Indian Constitution. Here I have mentioned this right to life in Article 3 of this UDHR, but this right to life has been guaranteed as a fundamental right under Article 21 of the Indian Constitution. Right against arbitrary arrest, this kind of protection is provided in Article 22 of the Indian Constitution. Though the things are provided in our legal system, in Indian legal system, in different provision, but objective is same. Purpose of all these provisions are same, and the purpose, the sole purpose is to prevent custodial violence. Whether these provisions have been incorporated in international instrument or these protection are incorporated in legal system, in our legal system, the purpose of all these human rights is same, and the only purpose is to prevent custodial violence, so that the dignity of human being can be maintained, and so that people can enjoy their rights provided by the statute or provided by the Constitution. So, these are few important human rights which you need to remember, and then after we come to statutory protection. So, we will try to understand that under what circumstances custodial violence takes place, and what are the statutes where people are protected from unwanted arrest, people are protected from custodial violence. So, I will try to explain one by one. You just look at your screen. Section 24, I have referred few important provision of statute. Section 24 of Indian Evidence Act, Section 25, 26. All these, you see, all these statutory provisions have been incorporated in the statute to prevent custodial violence. How these provisions are helpful in preventing custodial violence? You just see Section 24. I would like to explain one by one. 162 and 163 of CRPC, Section 341 IPC, if someone is arrested by police officer wrongfully, so that police officer, you don't think that police officer cannot be prosecuted and convicted. If police officer or arresting officer has arrested someone wrongfully, so in case of illegal detention, wrongful arrest, that police officer can also be prosecuted and convicted. Section 341 of the Indian Penal Code makes it clear that where wrongful arrest is made by police officer, that police officer can also be prosecuted and convicted as a common man. So, you don't think that police officer, they are protected, they are exempted from criminal liability. If they commit custodial violence, if they commit crime and crime is proved before the court that police officer has committed this crime, even that police officer can also be prosecuted and convicted by the court. So, I would like to explain all these statutory provisions one by one, so that you can have complete understanding about these statutory protections. So, let us understand about Section 24 and 25 of the Indian Evidence Act. Section 24 says that no inducement or threat shall be given by police officer at the time of investigation, meaning thereby at the time of interrogation, police officers are prohibited not to give any kind of inducement or threat to the person to whom they are asking question or to whom they are interrogating or instigating. So, if police officer obtain any kind of statement under threat or under inducement, then that statement would be irrelevant under Indian Evidence Act 1870. That statement cannot be proved against the person who has given a statement under threat or compulsion or inducement. So, the moment it is proved before the court, and you can imagine in this digital era where investigation is going on, and investigating officer is asking question to you, and if your voice is recorded, if you have recorded your voice statement by that digital, by mobile phone, then you can prove before the court that this is the documentary evidence at the time of interrogation. This is my voice recording. At the time of investigation, when police was interrogating, police compelled me, police threatened me. If you will not give your statement, then I will prosecute you, I will beat you, I will torture you. This kind of statement, if police has given during investigation, you can prove, you can record his voice, and you can prove that recording before the court, and it will be very important evidence. And police. So, you see, in this digital era, things are very easy to prove before the court, and the chances or possibility of threat or inducement or torture, now you can say that insignificant, have become insignificant, or the police officer, they also they will think twice in giving threatening or inducement to the accused or witness. So, this kind of section 24 gives protection to a person not to give any statement which may implicate him in any crime, and if inducement or threatening, if he is threatened, witness or accused is threatened by police officer, then that statement would not be considered as a piece of evidence. Section 25 of the Indian Evidence Act is very important, which I would like to refer in this lecture. Section 25 makes it clear that where any accused who has confessed, who has admitted his guilt to the police officer, admission of guilt would not be considered as a piece of evidence before the court of law. Neither statement, confession to the police officer or confession in police custody would be considered as a piece of evidence. Why? The reason behind not accepting confessional statement given to the police or in police custody as a piece of evidence is chances or possibility of inducement or threat. Law presumes that it is presumption of law. Law presumes that if his statement is recorded by police at the time of investigation from the accused, neither accused was tortured and police officer is very honest, but law presumes that if police officer has interrogated this case and statement was made by accused in the presence of police officer, there would have been apprehension in the mind of accused. So, with this notion, law does not accept such kind of statement as a piece of evidence. So, law presumes that presence of police officer will make that statement irrelevant, because the statement is made by accused under compulsion or threat. There must have been fear in the mind of statement maker, and that is why this statement should not be considered as a piece of evidence. So, you see, this kind of provision, this kind of statutory provisions are very helpful for the accused as well as for the witness. This kind of protection is also provided in Constitution under Article 20 clause 3. Article 20 clause 3 also gives liberty to an accused not to make such kind of statement which may implicate him in any offence. So, Article 20 clause 3, which is actually written in Constitution, I would like to refer. No person shall be compelled to be witness against himself, meaning thereby no person can be compelled by police to become a witness against himself. If someone is compelled by police to become witness, to give a statement which may implicate him in any offence, that compulsion, that statement would be of no significance, would be of no importance, and court will reject that statement which police officer has submitted before the court, that this accused, this offender has accepted his guilt in presence of me, in presence of investigating officer. Court will not accept that statement. You need to understand this thing. So, these constitutional provision and statutory provisions are provided in the statute and the constitution just to prevent custodial violence. So that police, if police officers, they are very much aware about all these things, that if they will obtain statement under such circumstances, court will not consider their statement, court will not accept this kind of statement, this kind of evidence. So, what is the use of obtaining statement from the accused? They do not record this kind of statement, because police officers, they are very much aware about all these provisions. The moment they will provide evidence before the court that they have recorded a statement of the accused has accepted his guilt. Let us understand with the help of example. Suppose where murder is committed by Mr. X, X has been nominated in FIR. As per FIR, police officer has arrested Mr. X, and Mr. X has confessed his guilt in presence of police officer, investigating officer, that he killed Mr. X killed Y. So, here Mr. X has admitted his guilt before police officer, and police officer is trying to prove this statement before the court. Court will not accept this statement. Court will never accept this statement as a piece of evidence, because this statement comes within purview of section 25-26 of the Indian Evidence Act. This kind of protection is given to the accused, so that police officers, investigating officers, they do not commit custodial violence. In order to prevent custodial violence, these safeguards have been given to the accused. But on the other hand, if accused has confessed his guilt that he killed Mr. X killed Y, and Mr. X killed Y with this pistol, with this weapon, with this knife, if pistol is recovered, if knife is recovered, then that material, that weapon can be proved against the accused. Another aspect of his statement is not relevant, court will not accept that statement, but the material weapons recovered on the basis of the statement of the accused, that weapon or that material can be proved against the accused. Because a person may lie, but circumstances or weapon or facts cannot tell lie. So, on that basis, court will consider, court will accept pistol or weapons used in that crime as an important piece of evidence. So, this is all about section 24, 25, 26. As I said, these statutory provisions have been provided in statute to prevent custodial violence. Section 162, 163, CRPC also, Criminal Procedure Code 1973, makes it clear that no inducement shall be given by investigating officer to any person, to any accused who has committed any crime, nor any person. Section 162 CRPC says that nor any person shall be compelled to give statement at the time of investigation. So, you see there are procedural safeguards also. These safeguards have been provided in this procedure, that at the time of investigation, person accused or witness, they are not supposed to give that statement which might implicate him in any offence. So, they are free not to give that statement which can implicate him in any crime. Now, third, you see the another aspect of statutory protection is, if someone is, I have already highlighted those human rights which are provided in UDHR, protection against arbitrary arrest, unlawful arrest. If suppose if someone has been arrested by a police officer wrongfully, what is remedy available to that arrested person? Arrested person has two options. First, he can challenge the legality of his detention, or he can knock the door of High Court under Article 226. Directly that arrested person can directly move before the High Court. So, question may arise that if person who has been arrested by the police officer, how he will go to the High Court? The question is, his relatives, the relatives of arrested person, they may file application to the High Court by saying that relative has been arrested by the police officer and has been kept in police lockup. So, relatives of the arrested person, they can move before the High Court, they can file application in the High Court, and High Court will take cognizance, and High Court will direct to that police officer who has arrested in arbitrary manner wrongfully, and habeas corpus, the order which is issued by High Court is known as writ of habeas corpus. So, habeas corpus may be issued against that police officer by saying that you produce that arrested person before me, before this honorable High Court, so that I can see whether you have arrested this person wrongfully or you have arrested this person in lawful manner. So, we people will decide, High Court will decide. So, if High Court is not convinced with the argument of the police officer, then High Court at that very moment may give order to the police officer to release the arrested person. So, this is remedy available to arrested person. So, he can move before the High Court, relatives can move before the High Court challenging the legality of his arrest. Second option, second remedy is once High Court or Supreme Court declares that detention unlawful, illegal, after having that order, after having the copy of that order, arrested person who has been now released by the court, he can lodge FIR against the same police officer who has arrested him, who arrested him wrongfully, he can lodge FIR, and the provision which will come into picture, that is section 341 of the Indian Penal Code, that is wrongful confinement. So, wrongful confinement, if someone has been confined wrongfully by any individual or by any police authority, he may also be prosecuted. Wrongful confinement is an offence under section 341 of the Indian Penal Code. So, that arrested person who has been released by the court now may lodge FIR against the arresting officer, police officer, and police officer may also be prosecuted and convicted for wrongful confinement. So, what I have referred in this unlawful, in case of unlawful detention, this may also amount to custodial violence, where a person whose precious right to life or personal liberty has been violated by police officer, and he has committed any physical torture, police officer has used third degree method in the name of investigation, interrogation. So, third degree method, you all might be aware that would be considered as custodial violence, and victim arrested person has, as I said, two options. He can either, the relatives of the arrested person can knock the door of High Court, or he can lodge FIR against the arrested person. Apart from these two important remedies, arrested person has right to get compensation from the state. You see, this is another important right in the hands of arrested person. A person who is victim of custodial violence, court has declared him that his arrest was illegal. After having that order, he can also get compensation from the government. How he can get compensation from the government? Law presumes that police officer who was working on behalf of the state has arrested the person wrongfully, illegally. So, it is the duty of state to teach lesson to its officers, so that officer cannot repeat the same thing in future. So, this is, you see, this is the state liability. In this case, state would be held liable for that. High Court or Supreme Court may direct the state government concerned that your officer has committed this crime. So, that is why you are bound to pay this much amount as a compensation to the victim of crime, this arrested person. So, this is law on this point. I have, in this lecture, I have covered statutory protection against custodial violence. What are the remedies available to arrested person? I have also highlighted three important remedies. First is right to get remedy from High Court or Supreme Court under Article 226 or 32. Second is that arrested person can file complaint, FIR against arresting officer, police officer for wrongful confinement, and right to get compensation. He can also get compensation from the court. Suppose if he has spent 1 week in a jail, 1 month in a jail, 2 months in a jail, after 2 months, after 1 month, if his detention is declared illegal, unlawful, then he is entitled to get compensation from the state government. If he is businessman, or on the basis of his balance sheet, on the basis of his balance sheet, his income may be calculated per day, means what amount he gets from his business, he is getting from his business. So, on the basis of that amount, his income, 1 day income, and multiply by 1 week, 1 month, 30. So, this is the procedure for calculation of his income, and he will then, as per the direction of court, state government will have to provide compensation. Suppose 30 days, if he was put in jail for 30 days, so 30 days into 1000, in this much, that much amount he will get from the state government. So, this is compensation from illegal arrest. This and now come to constitutional safeguards. Now, we will try to understand whether there is any specific provision in our constitution. Constitution being supreme law of the land, you see, our constitution makers, they were very much aware about the things which were happening across the globe at that time. When our constitution was being drafted in 1948-49, when this our constitution came into existence in 1949, so we recognized certain rights as a fundamental rights, so that custodial violence may not be committed or police atrocities may be avoided. So, for that purpose, I would like to refer 3 important constitutional provisions: Article 20, Article 21, Article 22. Article 20 has 3 important clauses. Article 20 clause 1, protection against ex post facto law. Article 20 clause 2, protection against double jeopardy. Article 20 clause 3, protection against self incrimination. Apart from this, Article 21, 22, these 2 important provisions are also helpful to prevent police custodial violence. Article 21, as I said, talks about right to life. Right to life is a fundamental right, and you see what is actually written in Article 21, that no person shall be deprived of his life or personal liberty except procedure established by law. So, by this you can understand that even right to life is not absolute right. Anyone can be deprived from his precious right, committed murder. If he has breached the law, murderer has no right to live in this holy world. If someone has committed murder, then section 302 of the Indian Penal Code says that who has committed murder, he may also be awarded death sentence, death penalty, or life imprisonment. So, murderer cannot claim this protection as a matter of right. He has no right to live with human dignity because he has committed murder. So, it is specifically mentioned in that article, this right to life is not absolute right. This right can only be availed by innocent person. So, this is another. Now, come to another aspect of this fundamental right to Article 22, and you see Article 22 has 2 important components. First is right to be produced within 24 hours. So, this kind of protection is also available under Article 22. Article 22 also talks about right to have counsel at the time of investigation. You see how this Article 22 is helpful in preventing custodial violence. Article 22 specifically talks about that every arrested person shall have right to have counsel at the time of investigation. He can take legal assistance from advocate, he can engage counsel of his own choice, and Supreme Court has widened the scope of Article 22 by saying that every arrested person shall have right to have a counsel during the period of investigation. So, how you see Supreme Court has widened the scope, strengthened the scope of Article 22. Supreme Court said that if counsel, advocate would be present at the time of investigation, interrogation, then there would be less chances of torture, there would be less chances to use third degree method against the accused. So, accused should be given liberty to engage a counsel, to have a counsel at the time, even at the time of investigation. So, whenever investigating officer, police officer starts investigation, accused can ask to the police officer that this is my advocate and I have been given power by the Supreme Court to appoint this Mr. X as advocate and take legal advice from this, and this advocate will be present at the time of investigation. So that, so this kind of, you see, this kind of guideline, this kind of thing would be naturally, definitely helpful in prevention of custodial violence, and because mere presence of advocate at the time of investigation makes it clear that police will not use third degree method against the accused, because advocate may ask that you do not have power to ask this question, you do not have power to use third degree method, you are not authorized to use such kind of force, this is excessive force which you are using against this accused. So, advocates they are supposed to know all these things, and that is why Supreme Court has widened the scope of Article 22 by saying that accused shall have right to take legal advice from his counsel, advocate at the time of investigation, interrogation, advocate can have. So, this is another important constitutional safeguards against custodial violence. So, I have already highlighted the significance of Article 22. Now, come to these other statutory safeguards against custodial violence. There are certain provisions in the statute which also gives liberty to the accused. Now, right to how these statutory provisions are helpful, you see, right to know ground of arrest. So, you see, arrested person has right to know the ground of arrest. He may ask the police officer that on what ground you have arrested. So, if ground is not cogent, if ground is not adequate, so then arrest would be illegal. So, that is why arrested person has right to know the ground of arrest. So, at least police officer who is going to arrest somebody, he must inform the ground of arrest, then you have committed this crime, that is why I am going to arrest you. So, right to know the ground of arrest, this is the statutory right as well as fundamental right provided under Article 22 of the Indian Constitution. Right to be released on bail, you see how right to be released on bail, section 436, 167 CRPC, and I will explain these two provisions, right to be released on bail, section 436 CRPC and 167 CRPC remand. Arrest how made, section 46 has also prescribed the boundaries, periphery under which police officer, arresting officers are bound to follow that procedure. If procedures are not followed by arresting officers, then it would be against the spirit of section 46 and action may be taken against the police officer who has not followed the procedure. Arrest information to the relatives, these are other statutory safeguards. Now, I would like to highlight some important. So, how you see bail provisions are helpful in preventing custodial violence. Section 436, 436A, Section 167 CRPC. You all might be aware about one important provision of Criminal Procedure Code 1973, that is Section 436. Section 436 clearly says that a person who has been arrested in commission of bailable offence shall be released on bail. The word shall has been used in that provision. It means the release of accused is mandatory. Shall word signifies that release of grant of bail is mandatory to that accused who has committed bailable offence. So, bailable offences are those offences which are shown as bailable in first schedule, as you all might be knowing. Bailable offences are not serious crime, and Criminal Procedure Code has prescribed has categorized offences in two categories: bailable offence, non-bailable offence, considering the gravity of crime. Bailable offences are those offences which are punishable with less than 3 years imprisonment. Generally, this kind of definition bifurcation is made, categorization has been made by this statute, and non-bailable offences are serious crime. So, where a person who has committed an offence which is punishable with less than 3 years imprisonment, he shall be released on bail. So, if he is not released on bail, he is first degree offender, he has committed bailable offence. So, not granting bail to that accused would amount to violation of right to life or personal liberty guaranteed under Article 21 of the Indian. Court may declare that detention illegal, unlawful detention, and protection against unlawful detention is a human right. So, this kind of, you see, this kind of law, this kind of safeguard is provided in CRPC under Section 436. On the other hand, Section 167 CRPC also talks about default bail. Section 436 talks about compulsory bail. Bail must be given to a person who has committed bailable offence. Section 167 CRPC talks about default bail. So, here according to Section 167 CRPC, where police officer has failed to submit charge sheet within 90 days from the date of commission of the crime, the accused shall be released on bail. It means non-submission of charge sheet within 90 days would give liberty to the accused to take bail from the court. So, that is known as default bail. It is the default of the police officer, investigating officer. The investigating officer has not submitted charge sheet within prescribed time limit within 90 days. After the expiry of 90 days, that accused shall be released on bail if he is willing to give bail bond. Means that Section 167 says that non-submission of charge sheet within 90 days, negligence of police officer would not be considered as a license for violating the right of accused. He is innocent unless his guilt is proved before the court of law. So, that is why he must be released on bail after the expiry of 90 days. So, this kind of, you see, this kind of procedural safeguard are provided, protections are given in statute, so that custodial violence may be avoided, so that police officers or prison authorities, they cannot commit custodial violence. So, Section 436 and 167, also these three important provisions are also helpful in preventing custodial violence. And the most significant incident happened in the year of 2005. For your kind information, I would like to discuss Section 436A, which was inserted in the year of 2005. Just I want to you look at your screen. I just want to add Section 436A. This is a new provision which was inserted in the CRPC in the year of 2005. As you might be aware that Section 436A says that no person shall be detained in custody for more than that period for which he has been kept in jail, for which he has been alleged, meaning thereby no person shall be detained for a longer period prescribed for that offence in the statute. For let us understand section 436A of the CRPC, that where a person who has committed theft, the maximum punishment of theft is 3 years in section, according to section 379 of the Indian Penal Code, the maximum punishment for theft is 3 years. And a person who has committed theft is in prison, is in jail for more than 3 years. He has not been convicted by the court, matter is still pending in the court, and the charges against that accused is regarding commission of theft. Maximum punishment is 3 years, and he is languishing in jail for more than 3 years, 3.5 years. You can say he was in jail for more than 4 years. So, section 436A, after the commencement of this provision, that person must be released from the jail who has spent more than that period which is prescribed in the statute. It would be injustice on the part of the government to confine the liberty of an accused, even that accused who has committed theft for more than that period, which is not allowed by the statute, which is not allowed by the law. So, that is why you see this kind of protection is provided in the statute. This law was not in existence before 2005. So, can you imagine that the plight of those poor accused who had no means, who had no financial assistance to have good advocate, and they did not have sufficient money to engage a good lawyer. So, they were bound to live in jail for more than that period which they had committed offence in or which was prescribed in the statute. But you now can thank to the Supreme Court that Supreme Court intervened in this matter, that this is very the law which we are having right now is not good. Law needs to be amended by the parliament, and that is why law was amended in the year of 2005. So, this is another aspect of statutory safeguard. Now, let us see the role of Supreme Court, how Supreme Court has been effective in preventing custodial violence. So, with the help of judicial pronouncement, we will try to understand the efficacy of judicial system, how far Supreme Court has been effective. So, I would like to refer 3 important case laws. You just look at your screen. The first case is Joginder Kumar versus State of UP, AIR 1994. Second important case is D.K. Basu versus State of West Bengal, AIR 1997. And third important case is Khatri versus State of Bihar, AIR 1981, Supreme Court. So, I will try to explain the facts of these 3 cases one by one. Let us take first case, Joginder Kumar versus State of UP. You see what happened in this case. In this Joginder Kumar case, Supreme Court said that once the arrest is made by arresting officer, police officer, the information regarding arrest must be given to the relatives of the arrested person. Second important thing is that Supreme Court said that arrested person must be allowed to have a counsel. So, this you see how these 2 things would be helpful in prevention of custodial violence. If information regarding arrest is given to the relative of the arrested person, they will be active and they will take appropriate action. They will challenge the legality of that arrest in High Court or in Supreme Court. Habeas, they can move for the habeas writ of habeas corpus, or they can knock the door of superior police authority by saying that the arrest is illegal, police officer has arrested in illegal manner. So, that is why Supreme Court said that at least police officer can arrest. If someone has committed offence, if someone has breached the law, police officer can arrest. But on the other hand, for safety and security of that accused, information regarding arrest must be given to the relatives of the arrested person. Safety is major issue or security of that accused is major concern. So, Supreme Court expressed its concern over the manner of arrest or the use of third degree at the time of arrest. So, Supreme Court said that at least information of arrest must be given to the relatives. And second important thing is that if counsel or advocate would be allowed to give their advice to the police officer or they are allowed to present in the police station where accused has been kept in police lockup. So, advocate may ask to the police officer on what ground you have put this accused in police lockup. So, advocate at least may be helpful, may also contribute his services to prevent custodial violence. So, that is why this is very good guide. Another important case on this point is D.K. Basu vs. State of West Bengal. D.K. Basu case is a leading case on this custodial violence. In order to prevent custodial violence, Supreme Court has issued various guidelines in D.K. Basu case. How arrest shall be made? Section 46. Under what circumstances a person can be arrested without warrant, that is provided in section 41 of the CRPC. Arrest are considering the gravity of dignity of human being. Supreme Court has issued certain guidelines in D.K. Basu case that if these guidelines would not be followed by arresting officer, the arrest would be illegal. Not only arrest would be illegal, but the procedures followed by the police officer, arresting officer would be mandatory. If police officers they have failed to follow this procedure, this guidelines prescribed by the Supreme Court would amount to contempt of court. So, I would like to refer few important guidelines of D.K. Basu case. In D.K. Basu case again Supreme Court highlighted, emphasized the requirement of giving information of arrest to the relatives of the arrested person. Supreme Court said that it is legal duty of arrested officer to give information of arrest to the relatives, to father, mother, sister, brother of that arrested person. Second important thing, that arrest memo must be prepared by arresting officer at least in the presence of two citizen, two local resident of that area where arrest is being made by police officer. Two local resident must put their signature on that document, on that memo, on that report, arrest memo, so that judicial magistrate, trial court may see that in whose presence that arrest was made by the police officer, and they may also be called as a witness before the court. So, arrest memo must be, discovery memo can also be prepared by what material, what weapons, arms and weapons which was used in crime must also be recovered from the scene of crime, and that recovery memo must be prepared within 20. Production right to be produced within 24 hours, that is also a kind of constitutional safeguards. If a arrested person is produced within 24 hours from the time of arrest, it would be helpful in preventing custodial violence, because it gives an opportunity to become aware about that arrest. So, that is why it is constitutional obligation on the police officer to produce arrested person within 24 hours to the nearest magistrate. By doing this, judicial magistrate or magistrate may become aware that who has been arrested, or which authority, which police officer who has been arrested, and whether arrest is legal or illegal. So, this kind of thing, this is another important. Custodial violence, as you just can see on your screen, I have also highlighted few important case laws, that is custodial rape, Tukaram vs. State of Maharashtra. In previous lecture, I have also highlighted when police atrocities, I was talking about police atrocities. So, Tukaram vs. State of Maharashtra, you all might be knowing that in this case appellant Tukaram, he was a constable he had committed rape with this Mathura, a 16-year-old girl, in police lockup. This case was decided by Supreme Court, custodial rape. Sunil Batra vs Delhi Administration, 1979. The plight of prisoner was challenged in this case. Sunil Batra, he himself was a prisoner. He wrote a letter to a judge of the Supreme Court by highlighting the plight of his inmates, prison inmates. So, Supreme Court took cognizance. Nilabati Behra vs State of Odisha, IIR 1993. This is a case on custodial death, custodial torture, custodial violence. So, you see, you may see custodial violence into different color, into different forms. In these custodial violence may occur in different forms. Sometimes you may see that custodial violence, custodial physical torture, custodial death. Even death may also be caused by, you might have seen media report reveals that, and you, not media reports, you must rely on government data, government statistics, NCRB, National Crime Record Bureau, NCRB report on custodial death, NCRB report on custodial torture, NCRB report on custodial violence. So, you will get entire information. If you want to get that what is the actual position of custodial death in the year of 2023, then you can get information from National Crime Record Bureau is government website. So, you can get that information. Accountability of police officer, how police can be held responsible for custodial violence. We have two kinds of mechanism, internal mechanism, external mechanism. Internal mechanism, so far as internal mechanism is concerned, departmental inquiry can be initiated against him. They can be suspended or terminated from their services. Internal mechanism, internal methods to fix their accountability. External mechanism is judiciary can take action against them, and aggrieved can challenge the legality of arrest, custodial violence. So, judiciary can take action against the police officers. So, this is the external mechanism through which police accountability can be fixed. So, with this I think I have covered each and every aspect of custodial violence, right from statutory safeguards, and in this regard I have highlighted constitutional safeguards, statutory provisions, and role of Supreme Court in prevention of custodial violence. And I do believe that you all have understood the things which I have discussed. If you have understood all these informations and you will go through all these things, you will if you will memorize all these things, remember all these things, then definitely you will get success in your any examination where this kind of thing questions are asked regarding custodial violence. Case laws, I have all highlighted important leading case laws on this, and statutory as well as constitutional provisions. So, with this I would like to conclude my lecture. Thank you.
When Copernicus said the earth revolves round the sun, it was considered blasphemy. When Galileo said the earth was round, we thought he was mad. When Darwin said that monkeys are the ancestors of man, we thought he had lost it. When the ecologists said this was the end of the world and the human race, we didn't believe them.